All right, good. I apologize for that. So let's pick up there. Wanted you to look at Georgia Statute 16.523.1. Again, I'm giving you this not because I need you to memorize and know what the Georgia Battery Statute is. I just want to give you an example of statutory law. So this defines the offense of battery. A person commits the offense of battery when he or she intentionally causes substantial physical harm or visible bodily harm to another. As used in this code section, term visible bodily harm means harm capable of being perceived by a person other than the victim. It may include, but not limited to, substantially blackened eyes, substantially swollen lips, or other facial or body parts, or substantial bruises to body parts. So one of the things I'd like for you to appreciate about statutory law is there's no way to draw up a statute and list every single way that we could possibly have battery. We just have a general definition of it with some specifics, right? The harm has to be substantial. It has to be or visible bodily harm. It has to be physical harm. We know that from the thing, but it doesn't say anywhere in here that I can't take a crowbar and hit Khalil upside the head. But if I hit Khalil with a crowbar upside the head and smash his head in, then that conduct meets the definition that's laid out in the statute for battery. So that's how statutes are written. Sometimes they're as explicit and specific as the lawmakers intend for them to be. Sometimes they're real explicit. Sometimes they're more general like this. But that's an example of statutory law. Another example of statutory law is that was Georgia state statute that we looked at. Put in your outline an example of federal statutory law. So who would have passed this law, federal statutory law? Congress, right. All right, this is part of the Civil Rights Act of 1964. Title VII makes it unlawful for an employer to fail or refuse to hire or to discharge any individual or otherwise discriminate against an individual because of such individual's race, color, religion, sex, or national origin. We're familiar with that general premise of the law, but it is specifically found in a statute passed by Congress in 1964. A federal statute applies to everybody, all the states. The state statute applies to just people who are in that state, live in that state, do business in that state. Even if you're visiting that state, those state statutes apply to you while you're there. They govern the conduct of anybody in the state or doing business in the state. We'll get into this a little bit next week, but I might never set foot in Alabama. Well, let's say I might never set foot in Alaska. But if I run an online car business and I have a customer who buys a car online from me in Alaska and I ship them a lemon or I defraud them, you better believe that I'm subject to Alaska laws for fraud, even though I wasn't physically there. I did business there. All right, so that's an example of a federal statute. It is confusing with 50 states having 50 different sets of laws. So sometimes in some areas of the law, the states will get together and they will enact what's called uniform laws, meaning everybody's going to adopt the exact same set of laws when it comes to something. An example of that is the Uniform Commercial Code. So you don't need to know this for test purposes, but the Uniform Commercial Code, or the UCC, that contains a great deal of the law that pertains to business. It applies to anything, the sale of goods for over $500. So it's pretty widely applicable. And if we had 50 different sets of state laws dealing with the sale of goods over $500, that'd be really problematic in today's time. So what some states have done is they've gotten together and they've all adopted the exact same laws in a certain area. That's one example. Khalil. So the question is, if something happens over 4 or 5 different states, the person who took an action that was unlawful could be responsible in each of the state where the unlawful action occurred. So yeah, I mean, I could, let's say there's a federal statute against kidnapping, taking somebody across state lines. I could kidnap my neighbor's child and drive to California. And every state that I've driven through, I've violated that federal law. So each one of those states could charge me with kidnapping. So yeah, that's a good question. All right, so that is an example of statutory law. So before we go to the next area of law, let me ask you for a second. Let's say that I didn't hit Khalil with a crowbar. Let's say I hit Khalil with my pen. I just took my pen and threw it at him, hit him in the forehead. And he believes that that was substantial physical harm. And I say it wasn't. We can't even see the mark on it. But Michael says, well, I see the mark. I'm not the victim and I can see the mark. We've got this dispute. So he might sue me for battery under the battery statute. But we have an argument about whether or not what I did constitutes battery as it's defined. Who's going to sort that out? Who's going to sort out our dispute? Kenneth? The judge or the jury, correct. Very good. Now, let's say that we agree, or at my trial, the jury decides that me throwing that pen cap at Khalil, that the resulting mark on his forehead was substantial physical harm. And I say that that can't be substantial. And we argue about not what happened. We agree that I hit him with the pen, okay, and that I threw it. But what we differ on is whether or not that was substantial. So if we want to get an opinion or get the law further defined as to what the word substantial means, our courts do that. So we have courts, obviously, y'all know this, interpreting the law. And when courts interpret the law, they form written opinions, or they produce written opinions. And those written opinions get grouped together just like the statutes did, but the written opinions get grouped together in books or volumes by year and by court. And over time, we've got this buildup of written opinions that we call case law. That's just as much law as a constitutional law, just as much law as a statutory law. Case law originates from courts writing opinions. Now, this may be more detailed than you want to know, but I think it's important to understand the distinction. So, when you enter the court system, if I get arrested for battery, or if Khalil sues me for battery, my entry into the court system is at a trial court level. That's where there's going to be a jury, and that's where they're going to hear the evidence, and there's going to be cross-examination, and there'll be testimony, and they might see pictures and hear from a doctor. You're all familiar with that. We see that on TV and in the movies all the time. That's a trial court. The trial court determines what happened. Trial court would conclude, I threw the pen, and yes, it hurt Khalil, and yes, it was visible, and all these things. But if I appeal from the trial court's decision that I committed battery on Khalil, it goes up to a different level of court known as an appellate court, an appeals court. We're going to get into this more next week. I'm just talking about it now because I want you to understand that case law doesn't just come out of nowhere. So when I appeal it, I don't get to appeal. I never get to appeal what actually happened. Okay, I can't go to the appeals court and say, I didn't do it. The jury already found that I did it. The jury is the finder of all facts. Okay, the appeals courts don't retry the case and find out what happened. The appeals courts just decide whether or not the law was applied correctly. They would interpret the law. So let me give you another example. If you look back up in the Title VII of the Civil Rights Act of 1964, and it says in there that you can't discriminate in employment because of sex. All right, that's the text of the statute. There's a case we'll read later on in the semester where it's actually started in Georgia, where a DFACS worker believed that he was fired for being gay. And he sued DFACS and said that violates this statute, Civil Rights Act of 1964, because I've just been discriminated against on the basis of my sex. That was his case. At trial, the jury and judge would decide who said what, who emailed what were the discussions between the people that led to his firing. They're deciding what the reason was that this guy got fired. That's the trial court. They decide what happens. And let's say that the trial court said, yeah, you did fire him because he was gay. So if DFACS appealed to the appellate court, they're not going to be appealing why his name is Mr. Bostock, why he got fired. Again, that happened at the trial court level. They would be appealing to the appellate court and say, look, even though we fired him for that reason, the statute only says sex. It doesn't say sexual orientation. And cases in the past have always said that this word sex in this statute only means male or female, not sexual orientation. So that's an example of what the appeals court would decide. And they would write an opinion as to whether or not they believe the word in the statute sex includes orientation or not. That would become case law, the opinion of that court. So we don't get case law from the trial court. Trial court is guilty or innocent if it's criminal, whether or not somebody's liable or not if it's civil law, and they're figuring out what happened. Gets appealed, and the appeals courts are going to decide if the law was applied correctly, and they will write out opinions with their reasoning. And that gives us this long, long body of case law. So even though we could all read this statute from the Civil Rights Act and say that it says you can't discriminate on the basis of sex, we don't know if that includes sexual orientation until we have a court that decides whether it does and writes an opinion saying it does or doesn't. So what happens if the court writes an opinion and says the word sex in the Civil Rights Act does include sexual orientation? And I've told you that that's now law. So the next person that gets fired because of their sexual orientation, can they now sue using the Civil Rights Act of 1964? Yeah, they can. Because now we have case law that interprets this statute as saying it does include sexual orientation. So we can have a constitutional provision, we can have a statute, but we've also got to look at the case law and opinions that are interpreting those laws if we want to get the whole picture of what the law is. Ms. Willett. So that is a great point, and that's exactly where we're headed next. The reason that case law makes sense, or the way that we make it make sense from an orderly perspective, is that if a previous court writes an opinion saying, for example, that sex includes orientation, that becomes precedent and that becomes binding. If it didn't, case law wouldn't mean anything. It becomes binding. So the question is, does it become binding after one decision? That is a loaded question, because if it is decided by the Supreme Court, it's binding right then. Sometimes it's binding on everybody in the future. We have, and this is the thing for next week too, but we have the country's divided up into different circuits. And when you appeal, you go through the circuit that you're geographically in. So it's conceivable that an appeals court in the 11th Circuit, where Georgia is, could decide that sex doesn't include sexual orientation. And that'd be binding on all of the states that are in our circuit. But it's not binding on other circuits. And a different circuit could decide it differently. Then we've got a conflict, and then the Supreme Court would need to sort that out. So yes and no. Yes and no. All right, so that's precedent. The Latin name for that is stare decisis. That means let the decision stand. So we're bound by precedent. Also mentioned to you at the beginning of class that there's going to be a tension between predictability and stability in the law and the need to change. So precedent can be overturned. It happens. It happens all the time. Roe v. Wade is a great example of one that happened recently. The Supreme Court said that there was a right to abortion after or up until a certain time, and then that was back in the 50s. And then 2 years ago, I can lose track of time. I think it was 2 years ago, the Supreme Court said, nope, these state statutes that are banning abortion are constitutional. We're overturning the precedent. Now, courts can't just on a whim overturn precedent. They got to have a good reason for it. And they have to give their reason in their written opinion. That's how we distinguish in future cases what a decision meant or what it was. We get to read why they said that. And their reasons might apply to that case, but they don't apply so well to a future case. It's kind of how we get change. An interpretation of the separate but equal doctrine, which, if y'all know, that's from Brown versus Board of Education, which we're reading this week, that separate things for the races were constitutional as long as they were equal. That used to be the law. But when the Brown versus Board of Education case came along, that changed, and the Supreme Court overturned precedent. They changed the law. And you'll read in the opinion that I've assigned the reasons that the court used to support separate but equal before Brown. The court distinguishes those and says those aren't good reasons anymore. There's some previous cases that upheld separate but equal, but they were different than this case. They were about transportation. They were however many years ago. This amendment was written back when public education wasn't that big of a deal. Now it's probably one of the biggest deals the government does is educate kids. So they give their reasons for changing the precedent. And then once they do, that becomes the new precedent. So that's how case law works. There are also times when there might not be any precedent. We talked about this case last week, the Trump getting off the ballot in Colorado. That's never been decided by the Supreme Court before. There is no Supreme Court precedent. There wasn't precedent in any court until now. Now we've got this decision out of Colorado that's binding on Colorado, not binding on Georgia or Alaska or Michigan. But the Supreme Court has agreed to hear it. And so whatever they decide will be binding on everybody. They're going to interpret the 14th Amendment, Section 3, I think it is. They're going to interpret it for us in the context of a presidential election and insurrection for the first time. There is no precedent. Once they decide it, we'll have some precedent. Now, as a practical matter, when we're arguing cases, when we as lawyers are arguing cases, if the precedent is good for us, then we want to make sure that we argue to the court, my case is just like this other one. If the precedent is against us, we want to distinguish that other case from ours, right? We want the court to make a new distinction in the law and change the precedent somewhat. So we're always looking in prior case, in a case that if I have a case that I'm arguing, I got to look and see what the court has said about what this statute or what this constitutional provision means. And then I've got to decide if what they said about it in previous cases applies to mine or doesn't apply to mine because there's some distinction that matters. That's how case law works. I skipped, in the outline, I skipped administrative law. So let's go back to administrative law for a second. It's at the bottom of page 2. All right, so what time is it? Hey, 3:51. What'd you say, 4:15? Who said that? Oh, okay. I thought you said 4:15. I was like, that's dirty. So administrative law, got off track. The executive branch of government at the federal level and at state level creates agencies to carry out executive duties. All right, so it's the duty of the state of Georgia to collect taxes. The executive branch has created the Georgia Department of Revenue. That's the agency that collects taxes. On the federal level, the government's responsibility is to collect taxes. So we created the IRS. That's a federal agency. All of these agencies are part of the executive branch of government, either at the federal or the state level. Why are they relevant for our discussion today? Because they make laws too. We call the law that's made by administrative agencies administrative law. It's different. I mean, it's not like constitutional law where a bunch of old white guys were sitting around in wigs, but, dreaming up the Constitution. It's not statutory law where we've got legislature or Congress voting on laws. It's not case law. We don't have judges interpreting laws through written opinions. This is the agency itself making rules that are law. Administrative law, another word for administrative law is rules. Rule-making, administrative rules. But they have the effect of law just like the state of Georgia might pass a statute saying what the speed limit is. That's law. The Department of Transportation might print a regulation, might make a rule about the number of lanes in a highway. I don't know. That'd be law as well. So we've got to follow administrative law. We've got to follow rules from agencies just like we got to follow the rest of the laws. So practical application, Professor. Send me some examples of administrative law. Look at the top of page. So let me just give you some more examples real quick of agencies that you'd be familiar with. You're familiar with the Internal Revenue Service, Federal Trade Commission, the Environmental Protection Agency. They're the ones coming up with rules all the time about how much particulates of pollution can be in the air or water. Congress doesn't spend their time debating the milliliters per particle per milliliter of sulfate that's going to be in the discharge from a factory. But the Environmental Protection Agency sure does. They make plenty of rules about that. Example of a federal rule is, anybody deal with OSHA, Occupational Health and Safety Association, or Occupational Safety and Health Association? You do? All right, tell me about that, Michael. But as a first responder, you know that y'all have got certain OSHA regulations. What kind of first responder? Okay, the EMT. So there are going to be OSHA regulations about probably storage of medicine or chemicals. There are going to be regulations about disposal, regulations about your equipment. There you go. That's right. All that is coming from OSHA, and those are rules that OSHA made. So here's an example of one. This is a real one, and you can appreciate this because you work with it. If anybody else can, you can as well. Ladders shall be capable of supporting the following loads without failure. And it goes on to tell you what the loads ladders should support. That's not something Congress is going to spend their time passing laws on. It's better done, I would argue, it's better done by experts, or at least I mean, if I'm a U.S. Senator, I don't know anything about load-bearing ladders, but I would hope that the people in OSHA know a little bit more about that, and they'd be more appropriate to make those rules than me. Yeah.
The agencies that make calls, are they reviewed by Congress at all?
So good question. What's the review process for the agencies that make rules? We're not really getting into it in this class. There is a process for it. They can't just wave a magic wand and decree a rule. Basically, they've got to publish it. It's open for comment. After comment, they'll incorporate comments, and then they might publish again the final draft, and then it's finally adopted. Nobody really participates in the rulemaking. Citizens don't really much participate in the rulemaking process. I would say on average. It can be challenged in court. So a rule can't violate a constitutional provision. It can't violate a statute. So it's not just, these agencies don't have carte blanche to just make whatever rules they want to make. They've still got to be constitutional. They've still got to be legal. It's just that people don't, the rulemaking process is probably not as public or as involved as, I'm not going to say it should be, because I personally don't care anything about being involved in the rulemaking business. Somebody else might, but there might be an area where I care about it. I sure don't care about it in, the area of like tax law or something. Miss me with all that. An example of a state administrative rule would be our hunting regulations. So that's in your outline too. The Georgia Department of Natural Resources puts out the dates for hunting seasons. I've copied into your outline turkey hunting. Season runs from March 30th to May 15th for private land, April 6th through May 15th for public land. Limit 2 gobblers per season, daily bag of 1. That's the law. Not in the Constitution. It was not passed by the state legislature. No judge said that. It's not case law, but it came from the rulemaking powers and abilities of a state agency. So those are the 4 big main areas of law that I want y'all to be familiar with. Let's talk then about some basic distinctions that I want you to appreciate. We could divide law into a bunch of different categories. One way we talk about it is that we have substantive law and procedural law. Substantive law deals with rights between individuals or rights between individuals and society. Procedural law governs our court cases and how all that works. So if there's a law that says if somebody sues another person, they have got to provide notice and service of what they're suing them for to the person that they sued. That's a procedural law. If Khalil's suing me for battery, he is suing me under the substantive law that defines battery. So procedural and substantive laws are going to apply, and it's not either or. They're just different ways that we might classify certain laws. Same thing for federal versus state law. We went over this already, but federal law means who passed it. Congress. State law means who passed it. That state legislature, whatever state that is. All right. Probably the most important distinction I want y'all to be able to make is that we've got criminal law and we have civil law. All right. Criminal law defines the relationship, behavior that's expected or required between an individual and society. I can't murder somebody. I can't sexually assault somebody. I can't steal from somebody. That's criminal law. In criminal law cases, the person who brings the lawsuit is the government. If I broke a Georgia criminal statute, then that case is going to be state of Georgia versus Tebow. If I break a federal law, if I break that federal kidnapping statute by taking my neighbor's kid across state lines, that case is going to be the United States of America versus Tebow. That's criminal law. Everything else is civil law. Civil law is more the relationship between individuals. If Khalil sues me for battery, that's a civil law case. If I sue for employment discrimination, that's civil law. So anything that's not criminal law is civil law. Civil law makes up the vast majority of cases that are in our legal system. Most cases are civil law. But I do want you to understand that distinction. I'm going to muddy that up just a hair by saying that sometimes the same act can create criminal liability and civil liability. The most famous example of that is O.J. Simpson. Killed his ex-wife, allegedly. And he was prosecuted in a criminal case for murder by the state of California. He was sued by his ex-wife's family for wrongful death. That's a civil case. That was survivors of Nicole Brown Simpson against O.J. Simpson. Civil law. Criminal law results in fines, loss of liberty, jail, things like that, punishment. Civil law results in money damages. That's the difference. Kenneth. Yeah, so that's a great question. Corporations, for purposes of the law, are considered an individual. We obviously know they're not a living, breathing person, but they cannot get around any kind of law by claiming, well, I'm not a person. So, yeah. So, just one more time on the O.J. Simpson to drive that home. In the criminal murder case, the state was asking for O.J. to go to jail. They were not asking that O.J. pay the family money. That's between O.J. and the family. They sued him for money. The family, in a civil law case, could not have said, we are suing you for wrongful death and we want you to go to jail for it. That's not a civil remedy. But they could sue for money damages. It also explains how we could have what might appear to be contradictory results in those cases. Because in the criminal case, O.J. was found what? Innocent or not guilty of murder. So he was not punished. But in the civil case, he was found liable for wrongful death in order to pay her family millions of dollars. How could that be? What explains that? How could he be acquitted of murder but be found liable for wrongful death? Same set of facts. Different court. That is, yes. Different statutes. That's right. The main reason is, and those both explain it, the main reason is that in a criminal case, the burden of proof is different than in a civil case. So in a criminal case, that's right, in a criminal case, the government had to prove his guilt beyond a reasonable doubt. In the civil case, the family only had to prove that he was liable for wrongful death by a preponderance of the evidence. Preponderance of the evidence means more likely than not. 51% to 49%. Beyond a reasonable doubt is way up here, right? Not beyond a shadow of a doubt, not beyond any doubt, beyond a reasonable doubt. That's criminal. Why, just curious, why would we want different standards in a criminal case and a civil case? Annabeth. Bingo, that's right, because the consequences in a criminal case could be loss of liberty. And our founding fathers wanted to make sure that if we were going to lose our liberty, it was going to have to be because the government proved their case beyond a reasonable doubt. So that sort of explains the difference in those things. One other thing that can be slightly confusing is that sometimes we will have a civil law and a criminal law that cover roughly the same thing. So Let me give you an example. The OJ case was kind of an example. They were just called different things: murder and wrongful death. Similar, but not the exact same. Murder requires intent and premeditation, that kind of thing. Wrongful death is defined differently. As Kenneth pointed out, different statute, different law that we're talking about. But there is a civil law defining assault, and there's a criminal law defining assault. So, again, I could do the same thing. I could have thrown my pen at Khalil, and he could have sued me civilly for assault using the civil assault statute, and the police could come and arrest me and charge me with assault under the criminal statute, or one or the other. It doesn't always have to be both. Civil law is important in that regard because the government might not be interested in prosecuting every single assault. They might not want to waste their time on me throwing a pen at Khalil. Now, they've got bigger fish to fry, especially in Columbus, right? But it matters to him, so he's got a remedy by using civil law. So just kind of want y'all to appreciate those distinctions. What time is it? All right. Let me get into the constitutional powers of government for a minute, and then that'll leave us just a little bit for Thursday's lecture, and then we'll get into the discussions on Thursday. The top of page 5, I've already kind of talked about how powers are divvied up between the federal government and the state government and why that is. Some examples of constitutional features that are relevant to business would be, well, one is the separation of powers. We know this from civics, right? We have a checks and balance system of checks and balances so that no one branch of government has power over the other. What does that mean for us in business? It means that the courts, the judicial branch, can declare laws that are made by the legislative branch or the executive branch to be unconstitutional or illegal. The courts get to interpret what those laws mean. That's the check and balance that is inherent in the separation of powers as it relates to law. The courts get to police, so to speak, or interpret or invalidate laws from the other two branches. The Commerce Clause. Well, we've already talked about this. That was the example I gave you when we were talking about constitutional law, that the states gave the federal government the power to regulate commerce between the states. It's what we call the Commerce Clause. Very important because that is the grant of authority that the federal government uses to regulate just about every aspect of business that there is. The Supremacy Clause, we've talked around this already, but basically that says that nothing can violate the Constitution. We've mentioned that already a couple times in this class. Let's leave freedom of speech and due process and equal protection for Thursday's lecture. So before I quit, this is what we'll do. I will finish up pages 6 and 7 on Thursday, and then we're going to discuss Brown versus Board of Education. I went back and re-edited this case and took out more stuff that I didn't think was relevant. So it's even shorter than it's ever been. I'm trying to remember the trade-off. I'm not going to ask you to read anything that I don't think is important, but in exchange for that, you need to read what I think is important. That's our deal. So Brown versus Board of Education, it's not even 3 pages. And then there's an article about Brown versus Board of Education is the actual Supreme Court opinion. Now, it was probably 100 pages. I've edited it down to 3. I didn't start out with 100. I started out with, I can't remember. And I say that only so you'll appreciate the fact that when courts write these opinions, Supreme Court opinions are usually really long. But I've taken out all the stuff that doesn't really matter to the main idea. And then I've given you an article about the Kennedy versus Bremerton case. It is not an opinion. It's just a news article about the case, and it describes what happened and why. That was the case of anybody familiar with the football coach in Washington State who got fired for he was praying at the 50-yard line after games. Anybody heard of that case? Fairly recent. I had not really heard of it until I read about it either. But that was decided by the Supreme Court last year. So when we talk about those, I'm going to be asking y'all, I know all your names now, so I'll be asking you questions about those reading assignments, and I'll expect you to have read them. It's 6 pages total. It's not a ton for this week. All right, anybody have any questions? All right, I'll see y'all Thursday.